Hello and welcome to our webcast for September 7, 2018. My name is Christian Debré and this is Amy Asbrook, the director of Toujours Vivant, Not Dead Yet.
Hello.
And also joining us is Taylor Ayat, just on the corner here, okay? Our policy analyzer and outreach coordinator.
Hi.
Hi. Toujours Vivant, Not Dead Yet is a non-religious organization by and for people with disability and our allies. Our goal is to inform, unify, and give voice to disability rights opposition, to assisted suicide, euthanasia, and other ending of life practices that discriminates people with disabilities. Today's topic, there is only one, okay? The Accessible Canada Act. And to help us through that, Amy Asbrook.
Yeah, well, we need some help. We need help. Okay. So as we've already mentioned, the Bill C-81, or the Accessible Canada Act, ACA, was tabled on June 20th, 2018, just before Parliament broke for the summer. So
good timing.
Yeah, definitely good timing to get the news out there, and everybody was paying lots of attention.
Yeah.
So Taylor and I wrote a blog outlining the bill and some of its flaws. And also, the Accessibility for Ontarians with Disabilities Act Alliance has written a detailed brief about the ACA, and we recommend that you check out those sources and text version. There are links to all three, plus a description of the bill and the actual text. The ACA is not a civil rights bill. In the preamble, the ACA refers to existing laws prohibiting disability discrimination, including the Canadian Charter of Rights and Freedoms.
Could you tell us what is the difference between a civil law and other kind of law?
Well, it doesn't promote rights.
Okay.
Right. It doesn't. That's what it doesn't do.
We've talked in other episodes about laws that grant rights versus laws that give benefits or treats to people.
Yeah. And this one sort of does the second.
Yeah.
Gives more benefits. So it refers to existing laws like the Charter of Rights and Freedoms, the Human Rights Act, and the United Nations Convention on the Rights of Persons with Disabilities. But these are the only references to discrimination in the whole bill. The word never appears in the text itself. While the law provides for equal participation, it is silent on equality. So that's kind of might seem like not
a subtle difference.
It's an important difference.
Yes.
So equal participation versus equality. The bill calls for the progressive realization of a Canada without barrier. And there are 3 dots in there because they're skipped a whole phrase. And those 3 dots mean only as far as federal law allows.
Yeah.
Yeah. And that's not
of Canada. Okay.
Right. Only apply to organizations and services under federal control, such as broadcasting and communication, banks and financial services, transportation, international transport in between provinces, Parliament, the military and RCMP, and public lands, the Postal Service, and the Census. So not too many things that we deal with on a day-to-day basis except telecommunication. Contrast this with the activities under provincial jurisdiction, such as hospitals and healthcare, social service, cities and towns, property, civil registration like births and deaths, and family matters, transportation within the provinces, education, and housing. And last year we did a whole series on laws that provide for rights within the provinces, but And basically the Human Rights Act, when people bring complaints to the Human Rights Commission, that's where that case law is established. But that wouldn't be affected at all by the Accessible Canada Act. The ACA can't overcome the limited reach of the federal laws, have the limited reach laid out in the Constitution. The bill suggests cooperation, communication between the different levels of government to ensure civil rights protection.
Yeah, that's the
is about all it can do.
Yeah, that's all the trouble is. Where the trouble is, nobody actually politically want to touch the Constitution, even with a 10-foot pole.
Right.
Okay.
And so, for me, coming from the United States, where the federal government has a lot more control in the states by virtue of its power to tax and spend and also to regulate interstate commerce, that's how the Americans with Disabilities Act has its power to regulate private business and the affairs of state and local government. So that's why it's so disappointing for me.
Yeah, in Canada, this is a bit same thing, but just a bit. Mostly, it's largely limited.
Yeah, very limited.
The power is limited.
So Section 16 of the bill states that the minister may work with provincial or territorial authorities with a view to coordinating efforts in relation to matters relating to accessibility. So that's not just bad grammar, it's bad law.
Yeah. And as we've said,
it's Spanish somewhere.
As we've said in legal stuff before, may is not must.
Yeah, right, exactly. And also, yeah, in relation to in matters relating.
In relation to matters relating to. Yeah. Okay, how distant from the topic of accessibility are you going to be?
Pretty hot writing there.
Yeah.
The ACA is not even an architectural access bill. It lacks specific requirements and deadlines to achieve its goals. So it says it's going to do something, but it doesn't actually put any deadlines or specific requirements for what it's going to do.
Yeah.
It does not require that existing facilities be modified to become accessible.
Okay.
Nor that renovated buildings meet accessibility requirements.
Okay.
And it doesn't even reiterate the requirement that new construction meet access standards.
Oops.
So it says it's talking about removing barriers, but it's not enforcing accessibility standards.
No.
It might create some, but it's not.
Yeah.
It's not enforcing them.
If you are a building company and you are in a goodwill, you may sometime do something, maybe.
Right, but there aren't really severe penalties for failing to do that. And what often happens is the plans that the architect creates, the people who are on the actual job planning the thing say, oh, that's too wide. We can't do it that wide. We need to do a little more narrowly. And suddenly a door that was accessible becomes inaccessible. So.
And there's no penalty.
Right. And then the penalties are really either non-existent or they're just so small that people don't care.
Yeah. And to do it the other way, to provide incentives rather than penalties, doesn't usually work because people don't want to do these things unless you, excuse me, but kick their butt.
Right, exactly. Even though in new construction, it only adds about 1% to the cost. If you do it right, accessibly, it still, people just, even with incentives, they're not likely to do it. So, okay. So organizations governed by the Act must publish an accessibility plan describing the policies, programs, and practices practices and services, identification and removal of barriers, and the prevention of new barriers. So this is the plan.
That's a wish.
That they have to make plans.
They made the law over a wish.
Right.
Something like that.
Yeah. The agency or corporation is not required to appoint anyone to be responsible for preventing discrimination, implementing the plan, or removing barriers.
So they made a wish that maybe time to time, they may have one people responsible for it.
Right.
They may.
Right.
But not more.
Right. And so if you have a complaint about something, you have to take it to the Human Rights Commission. You can't go to the organization and say, I have a complaint. There's nobody there to take your complaint. There's nobody there who understands their obligations and is responsible for compliance.
Right.
Nor does the bill mandate that funding be allocated or deadlines be imposed for barrier removal. So, you know, we want to do this thing where they're gradually going to remove barriers, but we're not going to require them to actually appoint somebody to be responsible,
implementing it, or
fund it, or
whatever
put any deadlines.
Who is normally due to implement the law.
Right.
Okay.
Also, people with disabilities are supposed to be consulted on both the development of the accessibility plans and on periodic reports which show the agency's progress toward implementing the plan.
So you do nothing the first year, and if you do the double the next year, you have progress. But 2 times 0 is 0. So you progress quite a lot. You double your effort.
Right, and it says they have to consult disabled people. It doesn't say they have to actually take seriously what the disabled people say. And that happens a lot.
Right. I remember getting that sense in the early consultations leading to this legislation. Across the country, there were these public meetings where people could say their piece, but we had no assurance that anything was going to be taken seriously. Right. You could say that you had the meetings, but how do you know that things were going to be done with what we said at the meetings?
Right. Especially because they kept pretending like this bill could do so much, and it can't.
No.
And I just kept saying, but you can't do that. The idea that barrier removal, I'm sorry, I skipped a paragraph. So basically, the ACA is a bill about making plans to remove architectural barriers at an unstated time in the future, if the covered entity wants to. The federal, the federal agencies covered by the ACA are allowed to exempt themselves from the mandate to make, publish, and presumably comply with accessibility
the bill was so weak. Then they even identify a back door to make sure that everybody could escape wherever it happened.
Right.
Oh.
Yeah. Just in case.
So the most important word in all those things is if.
Yeah.
Okay.
Exactly. Okay. The Accessible Canada Act defines barrier as anything that hinders full and equal participation of people with disabilities. So there's some ellipses in there because I left out some segments of the phrase so that we could make it comprehensible. And this definition is so loose that a court may well strike it down as overly broad and vague. And that would happen in a situation such as if a business were penalized under the law, the business could say, we didn't understand what barrier meant because the definition in this law is so vague and it's so broad that we didn't feel that we were properly informed of what we had to do. And therefore, we were deprived of our constitutional rights. So that would be sort of the scenario that would happen.
Yeah. And they were probably with
right.
this
They might.
They might, yeah.
Yeah, I don't.
And might is more powerful than if.
Yeah.
Okay.
The idea of that barrier removal can end discrimination is an oversimplification, and it doesn't signal the positive steps needed to ensure equality of disabled people, such as requiring businesses to make reasonable accommodations or mandating a minimum level of accessible transportation services. And there's a lot of other things like that. Barrier removal also doesn't deal with many forms of discrimination, such as segregation, which is separating disabled from non-disabled people.
Which happen almost anytime.
Right, yeah, you had, oh, this is the tour just for disabled people, and this is the regular tour.
This bus is for only wheelchair.
Right.
Concert venues comes to mind.
Yeah. Oh, here's the wheelchair corral.
Yeah.
Another form of discrimination is having eligibility criteria that tend to exclude disabled people, like requiring a driver's license as identification. And that's actually less of a problem here because most people use the health insurance card for identification, but in the US, it was a big problem. I had to have a card from the Commission for the Blind of my state. So, because that was the only ID I could use aside from a passport that would be accepted. And another is charging extra for accessible accommodations, like providing video descriptive services or an accessible hotel room. The hotels are not above charging extra for accessible rooms. Well, it's bigger. No, it's supposed to be, whether or not it's bigger, it's supposed to be the same price because they have to make a certain number of rooms accessible. Okay. Nor does barrier removal address the public policy that favors institutionalization or agency-run personal care over giving people funds to hire their own attendants. This is a thing we talk about a lot. Such policies drive the demand for assisted suicide and euthanasia. So again, a barrier might be anything, but it doesn't really include this public policy problem. So how's that going to be addressed? It's not really. Oh, yeah. Another item related to assisted suicide and euthanasia, the bill is silent on the connection between barrier removal in broadcast radio and television and avoiding stereotypical portrayals of disability, especially the belief that life with a disability is a fate worse than death. So we've got all this news coverage of assisted suicide, and it's always talking about how brave and courageous these people are for fighting for assisted suicide because, of course, life with a disability is so horrendous. Who would want to live like that? And, there is already a thing that says they shouldn't use negative language, but this isn't considered a barrier. I don't know.
Yeah, they're not making the connection. In almost every other area, it's recognized that media is going to have an influence on how you look at the world.
Right.
And they don't realize that absorbing those messages and having them narrow your own vision for what your life can be is also a kind of barrier that they're putting up.
Right, exactly. And yet they keep saying, oh, this is great civil rights legislation. This no.
And by the way, looking at you, CBC, why is our national countrywide broadcaster always the worst?
And Radio Canada also are guilty. Let's see. The bill defines disability broadly as a physical, mental, intellectual, learning, communication, or sensory impairment that, in interaction with a barrier, hinders a person's full and equal participation in society. So doesn't, they're not talking about discrimination, they're just talking about hinders participation. So we're not going to bring in a civil rights bill, and why when they try to sell it that way, we shouldn't fall for it. This definition of disability has two major problems. First, it doesn't cover people who are discriminated against because they are believed to have a disability or have had a disability in the past or a record of having a disability or are associated with persons with disabilities. So if
in the past, when we was together at the beginning, I was not disabled.
Right.
Okay, but when we tried to enter a restaurant with a dog, okay, I was discriminated, but the guy of the restaurant doesn't want Amy to get in the restaurant.
Because of the guide dog.
With the dog, and I want to follow my wife, but we want to eat in this restaurant. So I was discriminated.
Right. So he was discriminated against based on association.
Yeah.
And for example, when the Americans with Disabilities Act was passed in 1990, when at that time AIDS was very, there were a lot of people with AIDS, and when there was a person who was gay and they were thin, that person was assumed to have AIDS.
He must have the SIDA.
Yeah, AIDS,
AIDS, in English is AIDS, sorry. SIDA is in French. Sorry.
So, you know, these are groups that were included in the Americans with Disabilities Act that were forgotten in the Canadian bill. The second problem with the definition is that it includes temporary or sporadic conditions, like maybe a broken leg. This risks making the definition so broad as to be unworkable and politically unacceptable. So people might just say, oh God, we can't take this seriously. You know, you're just including everybody. So
yeah, you broke a finger, you're disabled.
Right. That's what they're gonna say, is you're trying to include absolutely everybody. And they'll take it out on the law instead of just saying, well, maybe we need to make a modification. And while it's essential to include disabilities that are episodic and like multiple sclerosis and lupus, the terms used in the bill may well reduce the chances of it being taken seriously. So there's a difference between something that's episodic, which means it happens periodically and fairly predictably, or something that's sporadic, which means it may or may not happen at any given time. So if they had just used the word episodic, that might have been better.
Yeah, that would have fixed.
Yeah, take out the temporary, used episodic. That would be better. Okay, the Accessible Canada Act calls for the creation of 3 new authorities.
Authority.
Oh, yeah.
Must be interesting.
Bureaucracy. The Accessibility Commissioner is a member of the Human Rights Commission, so a person already exists.
Okay.
Which is the
but he gained a title. Okay.
Right, and this person has the primary responsibility for enforcing the statute.
And the responsibility. Okay.
Right. So this is the enforcer of the statute. And this person would provide technical assistance to the minister on accessibility issues. They would produce an annual report. They would be in charge of receiving and investigating complaints, and they would issue compliance orders under the Act.
But
so
there is nothing he could do with the complaint. He received it, but that's it. He may
no. I mean, he can investigate, and he can make findings, and then he can issue
a report,
penalties and stuff.
Okay.
But the thing is that the law also provides that the individual agencies are supposed to be responsible, but again, there are no regulations written. There's no one responsible within the agencies. So this is the only way that people can make complaints. And it's hard to believe that there would be enough staff to deal with the number of complaints, because disability rights complaints are the fastest growing kind of complaints that come into the human rights commissions. Yeah. Okay, so the next new authority that's being created is the Chief Accessibility Officer, and that person would advise the minister on accessibility issues. Doesn't do much. And also the Canadian Accessibility Standards Development Organization. And that group would, creating that group would allow the development of new accessibility standards. So it doesn't require it, it just says allows it. They can do that. Conduct research and provide information about how to identify, remove, and prevent barriers. These standards are not mandatory. So they can go ahead and produce standards if they want to, but the standards aren't mandatory.
Yeah.
And they won't have the force of law. And there's no deadline for producing them. The organization will have 11 directors, the majority of whom will be people with disabilities.
Okay, that's great. One thing positive. First thing.
And a chief executive officer appointed for a renewable term of 5 years. Okay, so that's good.
These are the parts of the law that made me feel like it was a glorified AODA, a glorified version of the legislation in Ontario.
Yeah.
Because they have standards that are slow to develop, that are at the whim of whatever government is in power right now. And they have one person in charge of investigating who probably isn't going to do much.
Yeah. Exactly.
Okay. And another thing, you must be positive. This law will create a majority of job, over 11 jobs in Canada.
Of people with disabilities.
People with disabilities. So it must have at least 6 disability jobs possible.
It's not clear that they'll actually be jobs. They may just be volunteer positions.
Oh yeah, maybe. Okay, sorry. It creates 6 positions at least for people with disabilities.
6 volunteer positions.
Yeah.
They don't necessarily get paid.
Maybe they could be paid. Okay.
Maybe.
Like the rest of the bill, maybe.
Maybe.
If that's the word in this law.
Yeah.
Maybe if.
Okay. The Accessible Canada Act imposes no deadlines for issuing regulations.
No deadline.
And
maybe if no deadline.
Right. And we know that with the assisted suicide and euthanasia law, which was imperative to issue regulations, it took them 2 years. And so it's a little worrisome that there aren't any deadlines for.
Yeah.
And finally, Section 133 of the ACA designates National Accessibility Week, starting the first Sunday of May of each year. Like the bill itself, it's a nice gesture, but it won't create the practical changes we need to achieve true equality. Accessibility Week is the equivalent of putting icing on a cake that, like the bill, is only half-baked.
Yeah.
So, any other comments, Taylor?
I also love the spelling in their cheesy little gesture at the end, because it's Accessibility Week.
Oh, aren't they clever?
How cheesy can you be?
We could give a clap for the bill.
Yeah. Well done, you guys. Yeah.
Big hand. Okay. If you have questions or want more information about the topics we discuss here irreverently,
sometimes, I don't know if you are like me, sometimes it's very, very, very disappointing.
Yeah.
And if you could say only one word about this law is disappointment.
Yes.
Is it okay?
Yeah.
Okay.
That's the one.
Yes.
So I'm okay. I'm not crazy.
Yeah.
Okay. Thank you.
Okay, so for more information about the subjects we discuss here, which are sometimes disappointing, you can visit our Facebook page at facebook.com/toujours not dead yet. Visit our website at tvndy.ca. You can also email us at info@tv-ndy.ca. Us on Twitter @TVNDY. Thanks to Christiane for helping out. And
Thank you,
thanks
Amy, and
also
thank
to
you,
Taylor for
Taylor.
helping out. Yay! And we will see you next time. Bye.
See you.
Bye.